Yes, Mr. Bowen.
Thank you, my lord. The advantages of the short adjournment is I was able to discuss the case with my team, and they brought to my attention a couple of factual points that I just want to make before I turn to the law.
Okay.
My learned friend asserted that the trust had complied with the policy, its own policy. The simple point is, my lord, that the policy suggests that an individual in her case should be visited. She wasn't visited. Whether that was because the message never got through to the community care coordinator or some other reason, it doesn't matter. She was not visited, and she should have been according to the policy.
I think it's important, Mr. Byrne, it is important to understand that Mr. Hoff didn't make that submission. He simply invited us to read the policy for ourselves. So I don't want him to feel pained. But anyway, we have the point, and we will read the policy with care.
I'm grateful, my lord. The second point is that in relation to the condition that I showed you, page 59 of the bundle, that Tanya should not return home without the OT, without the occupational therapist. And you'll recall I also showed you the entry after she had gone home with the occupational therapist when she was discussing the case with the nurse on the 28th of June, when the nurse had said she couldn't go home until her house was ready with the OT. And he questioned whether that was a condition that had been imposed for her own protection. He didn't say that it wasn't for her own protection. He just questioned whether it was for her own protection. Of course, it's going to be a matter for you. We submit that was a condition that was imposed, and there's no subsequent discussion in the notes as to why that condition was lifted. As to the point, the submission that I made that Dr. Chapman's evidence had been rejected by the Divisional Court, my learned friend is quite right when he says that Dr. Chapman's evidence wasn't rejected. What was rejected was the appellant's reliance upon Dr. Chapman's evidence to demonstrate that there was a real and immediate risk of death, of which the trust ought to have been aware. That submission was rejected, and indeed that is one of the reasons why we sought to rely upon Dr. Langton's evidence. Last point, as part of the agreement that was made on the 25th of June, Tanya agreed to be referred to the drug referral unit called ARCH, which stands for Addiction Recovery Community Hillingdon. And indeed, that referral was made after her second AWOL on the 4th of July, which you'll find in the notes at page 45. The only point I'd make in relation to that is that it's another example of the fact that the trust were aware of the drugs risk. They just weren't aware of the risks associated with it, which is what we say they should have been aware of. So those are the points we make on the evidence. He then made some submissions in relation to the Article 2 enhanced duty of investigation. And he took you to several authorities, including Smith, in relation to the question or the submission that was being made that it's not a presumption that there is a breach that is the forensic tool that is applied. It is just that there is a natural inference to be drawn in those cases where an automatic duty has been identified, that in such cases there is a breach. The first point we would make is that the presumption is the phrase that was used by Lord Phillips at paragraph 84. He had referred to him cases like Salman, in which the term presumption is used. That is the term that is used in the cases to which I took my lords yesterday. And the point is that it's not necessary for you to conclude that the only cases in which an automatic duty arises are those where it may naturally be inferred that there is a breach. What all you need to be satisfied of is that the criteria are met in which the courts have approached this question by A, requiring the state to account for a death, and B, that they then apply a forensic tool of there being a presumption of breach that can only be rebutted by a satisfactory and convincing explanation. And the criteria that are applied are those which were accepted by Mr. Justice Green in the Letts case, namely that a person is under the state's care and control, and that the evidence is exclusively or largely in the possession of the authorities.
Could we just have a look at what Lord Phillips said at paragraph 84 in Smith?
Of course, my lord. I think it's page...
Tab 40, bundle 2, 1184.
I'm obliged.
The obligation to hold an Article 2 investigation is triggered by the circumstances by so to give ground for suspicion that the state may have breached the substantive obligation imposed by Article 2. That in its turn raises the question of the scope of the substantive obligations that a state owes in relation to its armed forces, which I have raised above. Whatever the scope of those obligations, I do not consider that the death of a soldier on active service of itself raises a presumption that there has been a breach of those obligations. That's the only, as I read it, that's the only point he uses the word presumption. Am I right, or is there somewhere else? So so that's the basis upon which you submit that the test is presumption rather than inference, as Mr.
Well, he was referred to cases like Salmon. I've shown you cases like Salmon and Phenogonov and Zadziva, in which the Strasbourg court has used that phrase. At least Salman was cited to the House of Lords, to the Supreme Court in Smith, and it's our submission that it's the same principle that Lord Phillips is referring to in that passage. And you find the same. You find, in fact, Mr. Justice Green in the Letts case treated it in that way. If I could take you to what Mr. Justice Green said in the Letts case about that. If you'll just give me a moment, I'll find the reference. So Letts is at volume 1, tab 25. And the passage where he refers to Smith is at page 655 in paragraph 81. So he relied upon that in the context of his analysis, which my lords will, of course, in due course, if you haven't already, read. I'm not going to take you to the other passages, but that's where Mr. Justice Green refers to that passage in Smith. So we reject the submission made by Mr. Hoff that the test is, are the circumstances such as to give rise to an inference that in every case it's at least possible there is a breach. The Strasbourg court applies a lower threshold. The Strasbourg court applies the test that in every case there must be an independent investigation. See Zadziva. That is one that it must meet the requirements of Article 2. And in that investigation, the starting point in every case is that there is a presumption that the state is in breach of its duties, unless and until the state has provided a satisfactory and convincing answer. So
Mr. Bowen, Lord Phillips, as I read paragraph 84, Lord Phillips is, the principle of law that he is stating is the first sentence of paragraph 84, which is triggered by circumstances give ground for suspicion that the state may have breached a substantive obligation. And that would seem to me to be a paraphrase of what Lord Roger says in the earlier case, L, and repeated in his judgment, I think, in this case, in which he talks about possible.
Yes.
You're
Well,
right.
my Lord Rogers, of course, paragraph 59, I quoted it this morning, but he says in terms that in every case of suicide, I accept it's suicide, but in every case of suicide, you won't know without an independent investigation as to whether the state is in breach of one of its positive obligations. Now, I took you and have taken you to the case law in relation to the duty to provide healthcare, and I asked rhetorically the question, well, if you don't know in a suicide case whether a prisoner has died as a result of a failure of the state, by the same token, even when a prisoner dies apparently from natural causes, you won't know whether those natural causes were exacerbated or in some way by a failure of healthcare. And that is why you take the same approach in every case. Every death of a prisoner in custody requires an enhanced independent investigation. See paragraph 59 of Zidzava. Every case starts from the same starting point because the individual is under the care and control of the state, and because the evidence is exclusively or largely in the hands of the authorities, so that there is a presumption that there is a breach, which can only be rebutted by the state. Now, in many senses, whether it's a presumption or whether it's an inference is neither here nor there. It could be that we're discussing angels dancing on the head of a pin. What's important is to recognise what the touchstone is for whether that test, whether there is an automatic duty, and the touchstone is state care and control, coupled with a situation where the relevant evidence is in the exclusive control of the authorities, or largely in the control of the authorities. Those two factors are why detainees, military conscripts, fall within the detainee, fall within the automatic category. There are also, of course, the same factors that lead to the conclusion that an operational duty is owed to those groups. And that's why we say, as soon as you conclude that there's an operational duty to guard against risks that are exceptional, which include deaths from suicide, deaths from failures of healthcare, deaths from drugs overdoses, there's a duty to carry out an independent investigation, and the starting point is always the same. There's a presumption of breach unless and until the state discharges its responsibility of providing a satisfactory and convincing answer that it's not due to a failing by the state.
Thank you.
My Lords, in relation to Makarazzi, Mr. Hoff said that Makarazzi was not a case which involved the investigative duty. Can I just hold that one below the waterline by taking you to what the court said at paragraph 91? That's volume 3, tab 57. Sorry, it's page 1944.
Yeah.
And of course, paragraphs 90 and 91 are concerned with largely with the breach of the substantive duty. But then if you read the last 3 lines of paragraph 91, another serious omission was state's failure to account sufficiently by conducting an independent comprehensive probe for the cause of the first applicant's death. And I've already shown you paragraph 87, where the court refers to the duty of investigation by reference to cases such as Katz. Then in relation to the substantive duty, Mr. Hoff made a number of points. He took you to the case of Mitchell, And in fact, Mitchell is one of the cases to which I referred yesterday. I didn't take you to it, but it's an example of a case where the courts do address the question of whether there's a substantive duty owed in principle, because in the passage to which he referred, he showed you the passage where Lord Rogers said, well, there was no evidence of a real and immediate risk. But in any event, he said that that was irrelevant because there was no duty owed in principle, because housing authority does not owe a duty to its tenants to protect them from harm from a third party. The police may owe such a duty, but the housing authority does not, and it's in fact one of the cases we say illustrates why you need to, in some cases, certainly in novel cases, you need to break the duty down into the notional duty and the factual duty in the same way that you sometimes do in negligence cases. Mr. Hoff also submitted, by reference to Maguire, that the substantive obligation is tailored to harms from which the authorities have a responsibility to protect those under its care. Now, we accept that submission, but in deciding what are the harms from which the authorities have a responsibility to protect those under its care, one applies the exceptionality test in Raybone. Is it a harm which one can categorise as exceptional, or is it a harm which one can categorise as ordinary, i.e. one which the individual can be said to have assumed? Now, it seems, in my respectful submission, to be the natural consequence of his submission that a drugs overdose is not included among those harms, that even if a psychiatric patient, who is still an inpatient, were to take a drugs overdose in circumstances where the trust knew or ought to have known that there was a real risk of them doing so, and in circumstances where they knew that there was a real risk that if they did so, death would ensue, it's his submission, and it's the logical conclusion of the divisional court's judgment, that there could be no duty of care, even if the Osman test is satisfied, and that must be wrong. He asked rhetorically, would there be a duty of care if a voluntary patient while on leave was knocked down by a car in an accident? Well, I would ask in response, how do you know if it's an accident? How do you know if the patient didn't have a condition that meant that they were prone to taking risks that were foreseeable at the time they were allowed on leave? How do you know if Melanie Raybone, instead of hanging herself from a tree in the local park, had thrown herself under a bus, that was an accident or suicide without carrying out an investigation? The whole point about the investigation is that is the means by which you establish whether it was or was not due to some fault on the part of the state. My lords will be well aware of the statement that it is made repeatedly in the case law that the duty in relation to Article 2 and 3 is not an obligation of result, but one of means. So what is necessary is not for you to find that there's a breach. What you've got to do is you've got to carry out an investigation to see if there is a breach. I'll give you a reference where you'll find that in the cases. There's plenty of references to it, but you'll find it in the Jaskinkis case, which is volume 3, tab 53, at page 1730, and it's midway through paragraph 73 of that case. We say, this is our submission, that whenever a psychiatric patient is detained or admitted as a voluntary patient, there's a duty to protect them from certain harms. There's a duty to protect them from self-harm or suicide. That is not in dispute. But let's just test the hypothesis that Mr. that Mr. Hoff put forward, that is a duty that is owed even to a prisoner or a psychiatric patient for whom there is no history of self-harm or suicide. They may have never made any threats to kill themselves in the past, but the duty to protect them from self-harm or suicide still exists.
Yes, but it wouldn't. In those circumstances, Osman wouldn't. In the result, wouldn't be engaged because there was no real and immediate risk.
Precisely, but one would only find that out, my lord, by carrying out the investigation.
Yes.
And the duty to carry out the investigation is triggered by the death.
I don't think
investigation.
It may well be, Mr. Byrne, that we're going round and round in circles. There's no doubt that there has to be an investigation. English law has required that for the thick end of 800 years. I mean, what we're concerned about is the circumstances in which there has to be an investigation with the indicia set out in Jordan. So
yes, my lord.
And that's
no,
and I think, if I may say so, I think we have all these submissions, and they're not really responding to submissions from Mr. Hoff, or not. A lot of them aren't. They're restating the submissions that you made yesterday and this morning.
Well,
so I don't want to hurry you along if there are points in reply that you have to make, but I do think we need to avoid reprising submissions that you made yesterday.
Of course, my lord. Can we turn to the question of exceptionality of risk? Mm-hmm. And he took you to Zanzibar. And he said in relation to Zanzibar that was a case where, see paragraph 57, there were real question marks over whether the death had in fact been as a result of a drugs overdose. And he showed you the fact that there were indications that the prisoner could not have injected himself with drugs in the place where the needle was supposed to have gone in. So there was some suggestion that there may be some other cause of death. But my lord, that's entirely irrelevant to the question of whether the duty of investigation arose in the first place. The duty of investigation arose because on the face of it, Mr. Zanzibar had died from a drugs overdose. But that still triggered the automatic duty of investigation. And I repeat, the duty is triggered because the duty is one of means, i.e. you must carry out an investigation, not result. It doesn't matter what the outcome is. It may well turn out that the state is not to blame. In, of course, most cases it will turn out the state is not to blame. But that is not why the Article 2 investigation is required. Last, my lord, in relation to the Tyrrell case, my lord asked a question whether it said anywhere in the case law that there is an obligation of investigation in all detainee cases. My lord, one doesn't see the phrase in precisely those terms. I've shown you paragraph 59 of Zanzibar, which says the Jordan type duty has been extended to cases of deaths in custody. That's perhaps the highest one can take it. But that would include all deaths in custody. I've shown you Makaradze, which says that there's a duty wherever somebody dies as a result of an illness or a health issue. And I've sought to explain cases like Katz and Slimani, where there's a reference to a suspicious death triggering the duty by reference to the presumption and the duty on the state to account, which means that every single death, given the presumption that there is a breach, is automatically ipso facto suspicious. And those three lines of authority all lead to the conclusion that all prisoner deaths, and therefore all detainee deaths, which include military conscripts, which includes voluntary psychiatric patients, have the same duty. So then we're not in Ullah territory in response to my lord's other question. My lord, finally, I have prepared a document. It's entirely for your lordships, but it just contains the case references that I've taken you to over the last 2 days, where you will find them in the bundle as a simple aid memoir. If my lords would consider that useful, I can send it to my Lord Chief Justice's clerk. Aid memoir. Would you like me to hand that to your clerk?
Yes, thank you. You froze for just a second, but we heard what you were offering, and we're very grateful. We have looked at a very large volume of authority, and we've looked at a large number of passages in them, so an aid memoir would be enormously helpful. Very grateful indeed.
Thank you, my lord.
Very grateful indeed.
In that case, can I just finish by thanking the court for accommodating my difficulties caused by COVID, and I'm very grateful for the opportunity to have appeared in this perhaps not quite as unorthodox as my ones have been, but thank you.
No, well, Mr. Byrne, we're extremely grateful to you for having appeared in the way you have. It's not that unorthodox nowadays. Perhaps just another indication that yesterday's orthodoxy becomes today's heresy and vice versa. But if I may say so, you seem to be in very good form this morning. I hope that the ravages of COVID are not too troublesome for you, and we wish you a speedy, full recovery. We're enormously grateful. We're enormously grateful to everybody who's been concerned in this case for the written materials and also for the oral submissions that we've heard. We will take time to consider our decision, and we will produce a judgment or judgments in the usual way. We will circulate them in advance to the parties for correction of typographical errors and matters of that sort, and we will then arrange to hand them down without the need for the attendance of the parties. Given where we are in July, I'm afraid we will be unable to say that you will have the judgments before the end of July, but we will let you have them just as soon as we're able. So thank you all very much indeed.